dear eminent judges, senior counsels, and the staffs of National Judicial Academy. What does silence mean? It's a state. It's not a state where there is simply an absence of noise or absence of a conversation. It's a state of equilibrium, a state of being calm, a state of being very, very serene. That is how we understand silence, either in the philosophical terms or real life terms or in the constitutional sense. All the three are important to understand before we interpret the constitutional silence. As we as a land, as a country, are not alien to the doctrine of silence. One of the forms which communicate the best of truths, make you blissful, is the form of Lord Dakshinamurti. And such a Lord communicates in silence to its Sishyas. And Adi Shankara quotes it as Gurostu Maunam Vyakyanam Shishyostu Chinna Samshayana. The Guru sees the Sishyas, the Sishyas sees the Guru, and the whole transformation of bliss happens through silence. This also happens in our real life, as Dr. Justice Chandrachud was saying. A graceful smile through the eyes of our spouse, a slow nod indicating of acceptance, a overturn, an indication of dissent, and a frown, an indication of anger, happens in our life every day. And when it comes to managing things for our children, we do progress very slowly, first stage, second stage, third stage, before the final truth is revealed. In fact, recently, 2 days back, there was a WhatsApp interesting episode. A wife leaves her husband for a vacation for a week with her friends, and she leaves her pet cat and her pet mom with the husband's custody. After 4 days, she calls up the husband and inquires, "What happened to my cat? How is she?" The husband replied, "Dear, she is dead." Wife says, "You can't shock me like this. You should have told me the first day that the cat is on the roof. The second day, it broke its leg. The third day, it's fallen sick. And on the fourth day, you should have said it's died. I could have taken it seriously and in a pleasant way. Okay, I'll bear this in mind." Now she asks the next question, "How is my mom?" The husband says, "She's on the rooftop." So these are all modes of communication which we resort to. Constitution also does the same when it comes to constitutional silence, because it is also drafted by men, of course, of eminence, and spotted lines, dark dots are not conspicuous by their absence in any constitution, more so in a written constitution. How do you read a silence? There is a beautiful article on constitutional silences by Falli Nariman. Time permits, you should go through it. He catalogs 3 important guidelines when you open up a constitutional document. A, when it is a written constitution, it does not function on its own. It needs a special effort of nurture to sustain it properly. That's cardinal principle 1. 2, because we are a pluralistic society with diverse interests, a single constitutional document is something which has come out of persuasion, accommodation, and tolerance. So the Constitution as a document has emerged out of these 3, and therefore whenever somebody interprets it, this should be in the back of their mind. And 3, there is a lot of difference between enlargement of a duty and performance of a duty. And he makes a distinction. When there is a need, it's not that judges should only declare law. When there is a need, they need to perform the duty of filling the gaps too. But at only outer caution is, it should not lead to an enlargement. Duty, permissible. Enlargement, not permissible. These are the three rudimentary principles he suggests when you read a constitutional doctrine. Lawrence Tribe brings out the essence of silence in a constitution in the following way. The first aspect which we should do, which every judge, every counsel in a court pursuing a matter where there is ambiguity, where there is silence, the first attempt of a judge should be, is silence evident in that particular provision? He contrasts silence with avoidance. Has it been avoided or does it remain silent? This should be the first step a court has to take. Cognize whether there is silence. Now, the second feature he says is, once you cognize silence, then the next step is to assimilate that silence and interpret it closer to reality. There has to be an element of judgment in this, and the minds of the judges vary. It's not the same. So, the caution he utters is, when you assimilate it, try to assimilate it as close as is possible to what it actually intended to do. Now, he put the third angle, third perspective he brings out is this. He says, like sounds, which comes in various varieties, flavors, colors, contexts, perspectives, we must understand silence also comes in various forms, colors and perspectives. It's not that when it is silent, it has only one form or one tool or one principle. No. So we should not get ourselves entangled whenever we reach an area of silence that this should be the tool we should resort to. No. Have the same flexibility which you have for interpreting sound. That's the third tool which he recommends. And the fourth one, he says, any interpretation should be very objective. You should eliminate as far as possible subjective factors, more so when you interpret silence. Interpreting silence has to have extreme rationality and it should be completely free from subjectivity. And finally, this is what the goalpost, he says, the legal culture of a society is also dependent on how it interprets silence. If you refrain from interpreting silence, if you avoid interpreting silence, then the legal culture of the country cannot be progressive. So you should attempt enhance the legal culture of that particular constitution of that country, and therefore you are permitted to interpret silence. These are the 5 cardinal rules he suggests in his wonderful article. Whenever it's there, copies of which has been given to you. Now he also classifies the types of silence, very interestingly. There are silences of various categories. The first category of silence, he says, is door opening silence versus a door closing silence. So when you arrive at a silence, you should be in a position to find out through the process of assimilation, is it a door closing option or a door opening option? What do you mean by that? How do you determine that? He recommends, when it is unintended, an unintended lapse, unintentional, then give it the benefit of a door opening. Allow it to interpret, allow it to be assimilated as part of your constitution, and enhance it through, embellish it through an interpretation. But when it's a door closing silence, he says, where it is deliberate. I'm going to touch on this entry tax matter on this very issue when I discuss it. A majority and a minority judgment, both based on a platform, and we need to address to you to say which could possibly be the right for the future. So when I come to this door closing and door opening, this entry tax judgment will be the basis for discussion. This is one. Now the second type of silence, he classifies it as structural silence versus silence on individual rights. Basic structure doctrine, which came out of Keshavananda Bharati, is a doctrine which came out of silence. The seed was there in Article 368, but the interpretation is through. F.S. Nariman very nicely puts it in his article, a passage on that. How basic structure has come out, has evolved and has stayed, and it is nothing but a construction through a constitutional silence. So structural silence versus silence over individual rights and liberties. Article 21. The exponential expansion and growth of Article 21 is an indicator of a constitutional silence. Just two expressions, life and liberty. And where have we traveled? I just give you a short catalogue of how we have progressed from A.K. Gopalan to now noise-free, pollution-free era. How we have progressed, I'll narrate it in a couple of minutes. So that's the second category, structural silence versus silences over individual right. Then in an American context, he puts the third caution, general silences versus constitutional rules of interpretation. He refers to the 9th article, which article in the US Constitution tells you how not to interpret rest of the articles. So from an American context, he puts this as one of the principles of or tools of interpretation for silence. And the last caution he utters is reading of a silence versus a constitutional avoidance. Now, he says the trap normally for a judge lays here, because the attitude to pursue a constitutional philosophical thought has to be more from a neutral perspective, whereas an attitude to pursue a personal philosophical thought will be from an emotional perspective or a passionate perspective or an active perspective or a chance perspective. There are several categories in which we pursue our thoughts. So he utters a caution, when you decide a constitutional avoidance versus a constitutional silence, you must consciously ignore your personal passion over the subject matter. Only then you will be able to interpret that silence as how it has actually been intended in the Constitution. If it coincides with your personal passion, it's all right. But personal passion should not dominate the constitutional philosophy. It's the fourth type of silence which he recommends. Now let's come to the Indian context. Broadly speaking, constitutional silence has provided in the following 5 areas. A, basic structure. Starting from Shankari Prasad up to Minerva Mills. A complete turnaround we have achieved by finally throwing out the doctrine of basic structure. And it stays in our system not because it's the longest judgment or by the longest bench. Historical necessity, and in fact Mr. Nariman says in his article, but for the 39th and 42nd Amendment, there is every possibility basic structure document could have been given a burial. It's possible. Historically, these two amendments made it very clear and visible that a majoritarian government can do whatever it wants to do to the dislike of even the majority of the people. And therefore, the caution has been uttered to the basic structure document through Rajanarayan, though Keshavananda Bharati was one through which it was born, but Rajanarayan's case and Minerva Mills case looks to be the main factors, catalytic factors to sustain this in our system. The second one is Article 21, the Golden Triangle, Article 14, 19 and 21. From A.K. Gopalan to Karak Singh to R.C. Cooper to Menaka Gandhi, we have travelled enough. So, Now, where have we progressed in Article 21? It started with Eka Gopalan, but finally achieved the platform of a golden triangle in Maneka Gandhi's case. From there on, Olga Tellis, series of judgments, livelihood, better working conditions, food, water, education, medical care, shelter, decent environment, gender equality, Vishaka, privacy, reputation, pollution-free air, free from noise pollution. All this has, it's an explosion. In fact, it is, our silence has generated noise, sound, heat, light, everything in our constitutional package through its interpretative process. So Article 21 is one big milestone because of evolution of the doctrine of silence. Now the third piece is the most important piece, which I'll spend a few minutes and then wind it up. The entry tax piece on the door closing silence versus the door opening silence. Most of us believe that this nine-judge bench judgment on this entry tax issue is more to do with the taxes and more to do with Part 13. According to me, taxes is just economic aspect of it. This judgment has laid down a new seed on the concept of federalism. I don't know how many have read it from that perspective. It is a slow ticker, but a clear ticker. In fact, interestingly, when 9 judges in Bombay have said that true, federalism is part of our basic structure, but we lean towards a strong center. This judgment of equal strength has for the first time said that true, federalism is a basic structure, but we are slowly moving towards a state-centric federalism. This judgment has laid the seed or the foundation, which is something to be deliberated, which is something to be concerned with, something which we should find out as to what will be the roadmap for the future. How do they do that? That's important. Say there are 2 clear judgments and both are based on some platforms. Interestingly, the majority has gone by the philosophy of textual interpretation, door closing. We will stick to one principle, which is textual interpretation. The minority has moved away from that and said, we will follow the path of contextual interpretation. So, door opening. Now, why am I saying the doctrine of silence applies in this case? The question was whether tax is a restriction in Part 13. And the bench expressed a view, this aspect is silent in Part 13. So, when it is silent, the majority pursued the path of textual interpretation and the minority pursued the path of contextual interpretation. And where did it lead us to? Now, when Dr. Chandrachud was saying about the limitations of organic interpretation, there are limitations also in textual interpretation, in the non-organic passes. What are the limitations? A textual interpretation moves on a historical perspective. There are what are the tools of textual interpretation? History and literal construction. What did the judgment do? It referred to the constitutional debates. It stopped with 1950. It referred to the debates, it applied literal construction and said that we can't read tax as a restriction in Part 13. Whereas what did the minority do? When you apply the principle of contextual interpretation, you don't stick with history. You move out of history and you move with times. And when you move with times, you also become purposive construction. So the difference between textual and contextual, textual is literal and historical, whereas contextual is moving with times and it is progressive and it is purposive. So these are, now I'll give it to you. As judges, you can decide which of the two is advisable when constitution is considered to be a dynamic document, an organic document and a progressive document. And the second aspect of this judgment is, See, why are we saying India is a federal structure but leaning towards the center? We have one single constitution. We have one citizenship. We have one Supreme Court judgment, one Supreme Court whose judgment binds us. We have one IAS cadre. We have one CAG. And our territories under Article 2 cannot be ceded by anybody. Nobody has got a liberty to do it. So there are 15, 16 vital aspects in the Constitution which clearly point out that we are a centric-based federalistic structure, in contrast to the claims of the states for more powers. Why do states want? It's economic. Pure first reason is more money, more independence. But global philosophy of state-centric federal structure has thrown out its limitations very clearly. It brings out people with local ideas and local feeling. It promotes local feelings and at a center stage. And two, people with local aspirations occupy center positions and dispense center thought process from a local perspective. So all these things have been highlighted qua state-centric and union-centric federalistic structure. This judgment finally says, what has it said ultimately? President has been interpreted by the constitutional bench judgment several times as settled government. There are certain actions of state which gets approved, sanctioned. There are 6 terminologies used in the Constitution where President exercises powers under different articles. One such approval or ratification is contemplated in Part 13. This judgment has said, when it comes to tax, when the state has absolute legislative power to exercise its authority, we don't need a president approval for it. So it just removes the lid out of the Constitution. And what are the consequences? What is important, as Dr. Chandrachud was highlighting in the morning, Part 13, ironically, is one part in the Constitution which is non-federalistic. Federalism is absent in that whole part. It talks of a philosophy of a unified economic India. So you read a federalistic thought and you pursue the path to say this is more towards a state axis. And therefore, the door opening versus the door closing silence, the textual versus the contextual silence is the plain difference you have in this. And this is one judgment which deals with that silence, and it is a current judgment, and it may therefore be of importance for all of you to go through. My last 2 minutes, I shall wind up with that. I thought I'll just read a couple of sentences of there's an article circulated by me. Just 2 things I thought I will. There is an important quote of Justice Marshall, who says, "Not to enlarge judicial powers beyond its boundaries, nor does fear to carry it to the fullest extent that duty requires." When it comes to basic structure, historical necessity, the fear that majoritarian government can carry their will and priorities into the Constitution, and display of such conduct took away the basic structure documents from the clause of death and destruction to remain as an imperishable part of the constitutional architecture. Article 145 of the Constitution allows only the Supreme Court to be the final interpreter of the Constitution, which interpretation as the rule of law shall prevail and bind under Article 141. When it comes to this Article 21, this is what I have said in my final passage. If basic structure was a political compulsion to checkmate mindless majoritarian misgovernance, Article 21 is a conduit to connect every human being with his or her invaluable rights, which a state is under an obligation to provide to its citizens. Neither the framers nor the debates would have dreamt or visualized a meteoric progression of Article 21. The expression life and liberty had got associated with the aspects of social significance, and the endeavor has been to induce more quality standards and measure and embellish enhanced liberties, which remain even today as a distant daydream in a common man's life. Of course, every judgment on social progressions has its exteriors, interiors, and practical dimensions of translating these into real outputs. Since the topic is only on revealing the constitutional silences, it may do well to record only the progression and attempts have been made in laying the path. I will conclude with these words of my article. When erupting moments keep dying as they erupt, the doctrine of silence can remain still and in the dark. On the contrary, if eruption sustains and threatens to draw attention, breaking the silence through a meaningful contextual interpretation becomes the duty of the court, as that alone would augur hopes and instill faith in the minds of our people. Thank you so much.